So we're going to transition into Buck v. Bell at this point. Um, Buck v. Bell is one of the earliest cases that deals with this idea of privacy. It is one of the um, self-inflicted black eye cases of the U.S. Supreme Court, um, perhaps on par with Dred Scott and Plessy v. Ferguson. It ranks up there as among the most notoriously bad Supreme Court decisions. And so we're going to spend some time talking about the background and the aftermath of Buck v. Bell as well, because this case needs to be put into a significant amount of context to get the full breadth of what was problematic about this decision. Um, Before this decision even happens, there's a few earlier cases in the lower federal courts, which strike down as unconstitutional certain laws concerning sterilization, especially with regards to prison population. So there was some history in the lower courts of looking at these sorts of issues. But the issue in Buck v. Bell was even broader than just looking at prisoners' rights and sterilization. In particular, Virginia had a law which provided for sterilization of inmates in state institutions who had what was considered to be a hereditary form of, quote, insanity, idiocy, imbecility, epilepsy, and crime. And it was viewed that all of these were, to a degree, hereditary. Um, you have to understand that at the time in 1927, the idea of eugenics was taking hold and widespread within the United States. And this idea of eugenics said that certain individuals were hereditarily predisposed to be of lesser class. And it's this eugenics idea which goes on to fuel the Nazis in Germany and the Holocaust to the Jewish population in Europe, and the Gypsies in Europe and homosexuals in Europe and on all sorts of classes. This eugenics-based argument was articulated as a means to eradicate them from the European continent. Well, you can see in this case, almost 20 years earlier, that this idea of eugenics is also being used and articulated. In fact, Justice Holmes, who writes the opinion of this case, uses the language of eugenics within the opinion. And so what the state of Virginia did is it provided for the vasectomy of males and the cutting of the fallopian tubes for females in cases where they were considered to have a hereditary form of any of those issues that the state of Virginia recognized. So in this particular case, Carrie Buck is a feeble-minded white woman who was committed to the state colony for epileptics and feeble-minded in due form. She is the daughter of a feeble-minded woman in the same institution and the mother of an illegitimate feeble-minded child. That was the quote from Virginia with regards to Carrie Buck. Now, not very much of that was actually true. It turns out that Carrie Buck's child was not actually of defective mentality. She, before her untimely death, due to some intestinal disease, she was on the honor roll of her school numerous times. So not at all of defective morality. Neither really was Carrie Buck nor her mother, though we'll deal with that a little bit later about why they were considered to be of defective mentality. Anyway, moving on, the institution believed that it was in the best interest of not only Buck, but of the society as well, if she was sterilized. The thought being, if she was sterilized, they cut off the ability of more mentally challenged individuals to be produced. So they presented a petition to the board of directors outlining their case. The institution did to the board of directors and included that procedure. There can be no doubt that so far as the procedure is concerned, the rights of the patient are most carefully considered, and at every step in this case was taken in scrupulous compliance with the statute. And after months of observation, there is no doubt in the respect of a plaintiff has had the due process of law. That's with regards to Buck's case in particular. But researchers later on found very clearly that a large number of individuals had been sterilized completely without their knowledge, that they were not informed, they didn't know. And though while Carrie Buck knew in this case, there were many other similarly situated individuals who absolutely were not at all informed that they were sterilized. Note that this case absolutely never mentions the right to privacy. No one claims the right to privacy, but it's absolutely implied. Um, the Supreme Court, however, answers the question and says there's absolutely no right to privacy in the case, and the law in question is not unconstitutional. Justice Holmes, before and after Buck v. Bell, is considered one of the era's most liberal protector of civil right and individual rights. He's absolutely not at all that in this case. And perhaps at least the quote that sticks out in my mind, it's a quote that I can easily remember on recall at any time, is his description of the situation in this case. And he says, "It is better for the world if instead of waiting to execute degenerate offspring for crime or to let them starve of their own imbecility, society can prevent those who are manifestly unfit from continuing their kind. 3 generations of imbeciles are enough." Justice Holmes is not articulating himself as a protector of individual and civil level rights. He is absolutely using the language of eugenics as the background justification for his decision that his opinion that there exists no right to privacy, at least with regards to individuals who are situated as Carrie Buck. So the court also deals with the sort of equal protection requirement because it's not a due process case. It's one based on it is a due process case. It argues that anytime someone throws out equal protection claims to the court, that it's a last resort sort of constitutional argument, which the court dismisses very quickly because they think that anytime you throw out an equal protection argument, at least in 1927, what it means is you're basically throwing the kitchen sink at the Constitution and hoping something sticks with the court. And so they dismiss it at the most basic protection. But we know, having done it sort of backwards, having done race cases and then gender-based cases, we know that equal protection clauses are oftentimes the only method by which groups can carve out any protection for themselves from the Constitution. But that individual rights revolution, which kicks off largely in the 1940s and sees its culmination in the 60s and beyond, didn't exist in 1927. And so the Supreme Court upholds this law with one dissent and allows the sterilization of individuals who are determined to be of lesser stock to go forward. So let's provide some postscript to this actual case. How did many of these individuals find out that they were sterilized? Well, researchers afterwards began to interview individuals who were committed to this asylum. And they asked of one married couple in particular, how does it feel to have been subjected to this procedure? And the woman's reply was this: "Now we know why we have never had any children, because we tried and tried all those years, but just couldn't figure out why I couldn't get pregnant." Absolutely had no idea that they had been sterilized. And that was true of many of the individuals that were interviewed that left this asylum in Virginia. And it's absolutely not at all an isolated incident, because in this particular case, Virginia introduced absolutely false evidence in order to get Carrie Buck sterilized. As an example, they said that she could not control her sexual impulses and that her birth of her illegitimate child was actually proof of that. It turns out that the illegitimate child that she had was caused by her rape on behalf of her cousin. Her cousin raped her, she became pregnant and had an illegitimate child. And they used that evidence as proof that she could not control her sexual impulses and therefore was a candidate for sterilization. Even more postscript, not just about Carrie Buck in particular. This particular institution in Virginia was known as the Colony, and it performed 20 sterilizations a day at the height of their eugenics program. In total, over 8,000 men and women were sterilized at this one facility. Furthermore, there were numerous teenage children at the Colony, many of whom were orphans because of their parents being put in the Colony, and who were absolutely not at all of any sort of deficient mental stock. Many of those kids also, some as young as the age of 15, were sterilized at the Colony. And we like to think of this as some sort of happenstance from long ago. Look, it was the 1920s in Virginia. We know better now. The Institute in this case ran this sterilization program until 1972. It's not ancient history. It's a very current portion of our society. There are swaths of men and women still alive who were sterilized in this program. And I don't mean to point a very stark arrow on Virginia itself. This was a nationwide issue. It's estimated around 72,000 people were subjected to compulsory sterilization in the United States. And in large part, that was because of the eugenic programs that were pushed in the States and thus given national precedent for them to carry forward, in this case, Buck v. Bell. And so this is a bad decision by the United States Supreme Court. And it's based on bad science. And it's the starting point for our discussion of privacy, because individuals were absolutely denied privacy and control over their own bodies as the state impeded against that. And we will see time and time again that the decision in this case is sort of the launching pad for where privacy comes from. And not many years later, in the next case we'll see the United States Supreme Court limit the decision in Buck v. Bell, but they don't overturn it. And in fact, Buck v. Bell doesn't get overturned for a long time. And so we have this program in Virginia that existed until 1972. And it's really a dark stain on the Supreme Court for not striking down the rule in question, but also lending it credence as good practice and good science.